Unit 3, Part 2. Let's carry on. Okay, so advance notice of a medical scheme. A notice period of generally 30 days is acceptable. The Registrar's Office scrutinizes all rule changes and requires schemes to submit their rule changes by 1 October each year so that it can process the rule changes ahead of the year in which the change takes place. Because every year from 1 January, it's new rules and benefits and contributions and so on. You cannot leave it up to number 99 till the 31st of December to send it in. No, that's why he wants by 1 October to give him ample time, enough time to work through everything to get it registered and approved for 1 January of the following year. However, because most schemes submit rules on the deadline day, as I just said before, the Registrar's Office is often unable to process the rule change applications in time for the schemes to inform the members and market new options or benefit changes. So you want to get everything done before so that you can inform the members also in time so that they can decide whether they're going to stay or whether they're going to downgrade at the same medical scheme or whatever. Schemes, therefore, often inform members of benefit and contributions changes before they have been approved. Yes, that's what's happening, and that is not right. The difficulty schemes have been submitting rule changes early in the year is that the trustees need to have a clear idea of their finances in the current year in order to accurately set contribution levels for the year ahead. Now, I am also a trustee of our complex where I stay, and I can relate to this. We look at our budget of last year. Every year we need to look at our budget for the following year. And then we look what have we spent so far on a certain item. Let's say we've got our own lawn mowers. They get serviced every year. Then we look at how much did we pay for services last year, and how much will the services be this year. We get good quotations. Then we see, all right, there was a 10% increase because the parts I have to use to service them is more expensive. The labor went up, all right. We used, let's say, 12,000 rands petrol for the lawnmowers in the complex last year, but then the petrol was 20 rand a liter. This year, petrol is 25 rand a liter, so times the amount of liters we use, you say, okay, so we're going to need an extra 2,000 because of the petrol that's more expensive. So instead of having 15,000 rand last year for services, maintenance, and petrol on the lawnmowers, we must have 20,000 rand this year. So we must budget 5,000 rand more. But we already said, okay, we've got a standard 10% increase. So on 15,000 last year, if you add a 10% increase, that will be extra 1,500, 16,500. Will it be enough for this year? No, it won't. Okay, so we must act, and that's how you plan, and that's how you go through every single thing to just make sure that you budget correct for the next year. All right. Okay, so let's look at M. M is the manner in which an annual general meeting or special general meeting of members will be called, and the quorum necessary and voting procedures as such meetings. Trustees are usually elected at annual general meetings. Now, yeah, this is the same for our complex. Every year there must be an AGM, an annual, and we call it it's an annual general meeting, and you take the A for A and the G for G and the M for M. That's your AGM. In short, every year you must have an AGM where all the owners come together and then they vote regarding the complex, the trustees, everything. Or if you've got a problem that you quickly have to resolve and you cannot wait for the AGM the next year, you can arrange a special general meeting. But there must be a quorum. Now, it differs from industry to industry, but just for an example, in our complex, we've got 50 units. And to have a quorum, there must also be a quorum. And the law of sectional titles required 75% of the owners must attend. Now, 75% of 50 is 37.5%. But obviously, you don't get half a person. So 38, sorry, not percent, people. 38 persons must attend out of the 50. So if you times it by 2, you'll see to get 100%, those of you think my math is not, is 76%, which is more than 75. Okay, so 38 persons have to attend the AGM to make it valid. If they don't attend, if you don't get 38 persons at that AGM or that meeting, you cannot proceed with the meeting. You have to cancel it and get a new date. The quickest you can do is 2 weeks later. And then 2 weeks later, then you don't need the quorum. Because otherwise, if you must have a quorum again and it's not 38 people, and you must do it again and again and again, and you will never have 38 people pitching. So it will be a disaster. You will never be able to have AGM. So the rule say the first time there must be a quorum. If there's not enough people, you must postpone. You cannot proceed that night with the meeting. You must postpone it. The quickest is 2 weeks, so it cannot be quicker than 2 weeks. Give everybody notice again. Tell them there wasn't a quorum, that you're going to have the meeting again. But on the second meeting, there don't need to be a quorum. Not at all. Okay, and then the trustees must also resign at the AGM, and then they vote for new trustees. Now, the trustees can say, we are willing to do it again. And then the people can say, yes, you did a good job, we vote for you again, or no, we're not happy with you, we vote other people. So yes, but every industry has got their own quorum rules, etc. And the terms and conditions applicable to the admissions of a person as a member and their dependents. Which terms and conditions shall provide for the determination of contributions on the basis of income, as we said earlier, your contributions is the basis of your income or the number of the dependents, or both of the income and the number of the dependents, and shall not provide for any other grounds, including, so you cannot base it on sex, age, past or present state of health, uh, uh, for the member or even one of the dependents, the frequency of rendering of relevant health services to an applicant or one or more of the applicant's dependents, other than for the provisions as prescribed. Oh, the scope and the level of minimum benefits that are to be available to members and dependents as may be prescribed. B, no limitation shall apply to the reimbursement of any relevant health service obtained by a member from a public hospital where the service complies with the general scope and level as contemplated in paragraph O and may not be different from the entitlement in terms of service available to a public hospital patient. Q. The payment of any benefits according to a scale, a tariff or recommended guide, or 2. Specific directives prescribed in the rules of the medical scheme. Action taken by the Competition Commission in 2003 and 2004 put an end to schemes and healthcare providers negotiating a tariff that schemes would fund. The CMS published a list of guideline tariffs known as the National Health Reference Price List, the NHRPL. So they make a National Health Reference Price List so that they can say, look, we can work on this price list. But as the Competition Act permits regulatory bodies to publishing publish pricing guidelines. The Department of Health attempted to take over the task of publishing the tariffs as the reference price list, but its authority to do so was challenged by the South African Medical Association, SAMA. In July 2010, the North Gauteng High Court ruled the process by which the RPL had been determined was unfair, unlawful, unreasonable, and irrational. The judge set aside both the 2008 and the 2009 RPLs. In the absence of any guideline tariffs, schemes produce their own scheme rates, and members struggle to compare benefits without having reference to any standard. Many doctors, especially specialists who are in demand, charge multiples of scheme rates, typically up to 300%, but even 400 or 500%. So now if your medical scheme only pays 100% and your specialist charge 500%, you are short 400% of the fee. Which you have to pay. So if the bill is 10,000, your medical scheme is 1/5. You see, 1/5 is 1/5. What is 1/5? It's the same as 2/10. So if yeah, so if the bill, let's say for a big operation, the specialist charge 100,000 rand. This and your scheme will only pay 20,000. So you short the other 80,000. Not that its mistake cost will be so much. That's more the total hospital bill, but that's just an example. If your specialist charge 10,000, the scheme will pay 2,000. All right, that's 1/5, 100% instead of 500%. So yeah, be careful for that. Medical scheme options that pay private providers at 300% of scheme rates are declining. You do get some of them that pay 300% of the scheme rate, so they will pay 300% off the 500%. It's 3/5. So on 10,000 rand, they will pay 6,000. But they are declining, and many schemes has followed this example set by Discovery Health, and they are only paid to a maximum of 200% of RPL. Oh, so that's a problem. So if the bill is 10,000, they will only pay 4,000, because 4,000 is 200%. Yeah, of the 500. This is 2 out of 5. 200% of the 500% equals 2 out of 5. Times 2 is 4 out of 10. Therefore, they will pay 4,000 instead of 10,000 for the specialist. Many, like Discovery, have introduced lower maximum rates of reimbursement after negotiations with specialists who agree to charge the scheme's maximum rate in return for direct payment. So now they negotiate. They said, all right, you want 500%, but you're going to wait 90 days. 90 days before Discovery will pay them. Discovery said, oh, if you charge 200%, we'll pay immediately. So then the specialist said, okay, we'll go for that one. So that's the power that the medical schemes now have. If they want more money, the specialist, they're going to wait 2 to 3 months. Or if they charge 200%, they can get it immediately. And the specialist and the doctors go rather for that. They want the money immediately. Because I know some of the doctors, they cry. For 2, 3, 4 months, they don't get any money. Nothing. They have to live on overdrafts. And then suddenly, 3-4 months later, the medical aid pay. Then they can clear all the overdrafts and they barely on zero again, and then they must wait 3-4 months again, and then dig into the overdrafts again. If they dig in the overdrafts, it's more interest they have to pay to the banks for going into the overdraft. So they don't like that. They want the money immediately. It will suit them better. So schemes advise members which doctors are in the networks, but members who make use of practitioners who are not in the network and charge private provider rates that exceed the rate of reimbursement on the members option can incur high out-of-pocket expenses. So if you don't want to go to their network doctors, which they've got an arrangement with, and you go to an outside this doctor, yeah, well, then you might have out-of-pocket expenses. After some unsuccessful attempts to set up a bargaining chamber in which maximum tariffs at which schemes would reimburse could be negotiated, Dr. Aaron Motsoaledi, the then Minister of Health, he's not the Minister of Health anymore, but at that time he was, approached the Competition Commission for assistance. In January 2014, the Commission commenced to work on its health market inquiry. That is what happened in the past. So the inquiry released its findings in September 2019, recommending that the supply side regulator for healthcare be established, and one of its roles would be to set up a multilateral negotiating forum to set a maximum price for PMBs and reference prices for non-PMBs. It suggested that an arbitration mechanism be put in place for breaking deadlocks. The inquiry recommended that providers, funders, government, and civil society prepare individual proposals on fee for service, tariffs, and present them simultaneously for negotiation between the relevant parties in a forum governed by the supply side regulator. The inquiry further recommend that the regulator be able to set conditions that specify what outcomes will be compatible with public interest and public policy, including the NHI. This may include maximum average tariff increases, the maximum increase in expenditure, and even the expenditure for each specialty. A maximum tariff would be set for the PMBs that would be binding on providers, and schemes and guideline tariffs would be published for other healthcare services. There have been no further developments on these proposals. R. The dependents of a member are entitled to participate in the same benefit option as the member. S, T, and U. These parts deal with the continuation rights of members and the movement of members who are members by virtue of their employment. Unlawful actions by a medical scheme. So what is unlawful regarding a medical scheme? A medical scheme that acts outside of the scope of its rules. In other words, is not following its rules or in a manner that conflicts with one or more of its rules. So they go against their rules, is acting unlawfully. What is the purpose of rules? To stay inside the rules, to follow your rules. So if you go outside your rules or against your rules, that's not right. So as such, the following actions are unlawful. A. When they deny a benefit to a member when the scheme rules allow for such a benefit. So they said, okay, you've got 2,000 rand for glasses, or let's say for an optometrist, and now you go see the optometrist that he charged 2,000 rand, and now they said, no, they're not going to pay for it. You got the benefit, they cannot go against it. B. Imposing a late joiner penalty on someone who does not meet the criteria for such a penalty. That's not fair. C. Refusing to admit a person as a member of a medical scheme because the person is over the age of 65. You cannot deny access because of age. No. Refusing to pay for treatment for HIV. Refusing to admit someone as a member because the person is HIV positive. And if charging a member of a scheme higher contributions than other members who are on the same benefit option. It's not allowed. Consequences for unlawful activity. The scheme could be directed by the Registrar of Medical Schemes to rectify the situation. This could mean paying a claim that was refused or reinstating the member whose membership was unlawfully terminated or registering as a member someone whose application was refused or refunding contributions or other amounts of money to which the scheme was not entitled. In some cases, the scheme's failure to observe its rules or comply with the provisions of the Act could be a criminal offence. The scheme could be directed by the Registrar of Medical Schemes to rectify the situation. It could mean paying a claim that was refused, reinstating the member whose membership was unlawfully terminated, registering as a member someone whose application was refused, or refunding contributions or other amounts of money to which the scheme was not entitled. In some cases, the scheme's failure to observe its rules or comply with the provisions of the Act could be a criminal offence. For example, it is an offence for a medical scheme not to comply with the provisions of Section 35 of the Act, which require a medical scheme to, at all times, maintain its business in a financially sound condition. The Act states that every officer of a medical scheme who is a party to the failure of the scheme to comply with the provisions of the Act is also guilty of a criminal offence. The criminal penalty for being found guilty of an offence, as provided for in Section 66 of the Act, is, look here, a fine or imprisonment for a period of 5 years or both. So, you can get the fine or you can get imprisonment of 5 years, or you can get both the fine and imprisonment for 5 years. Or they. Medical scheme members who are aggrieved by the actions of their scheme should first complain to the principal officer of the scheme. So don't run to the ombud first. You first go to the principal officer of the scheme and you complain and you say your say. If the member is not happy with the response, the member should ask the principal office to refer the matter to the scheme's disputes committee. The disputes committee should be made up of 3 members who are not board members, not employees of the administrator or officer of the scheme. They must serve for 3 years and one of them must be legally qualified. The principal officer must convene a meeting of the disputes committee, giving it and the member 14 days notice of the date, time and venue of the meeting. So they must have the meeting, they must give you 14 days notice where the meeting is going to be, what date and what time. Yes, so when we look at complaints and appeals, the committee must decide which aspect of a complaint it needs to hear. If the member of any other affected person does not like the outcome of the disputes committee, they can appeal the decision to the CMS. The CMS complaints process is provided for in Section 47 of the Act. The CMS annual report for 2022-2023 noted that the Council received 2,966 new complaints for the year, but they resolved 3,070 complaints within that year, and it might as well also be, now you say, but how can they resolve more claims than they received? Remember, they received the previous year, they received thousands more. I don't want to put that, thousands more, plus these ones. So maybe if they received 1,000, the total will be 3,966 of the ones for the previous year and the ones for this year. If you add them up, let's say that was 1,000. Okay, so let's say it was 1,000 received the previous year, plus these ones, give me 3,966. So the ones the previous year plus the ones I received, they resolved 3,070. Most of the complaints the registrar's office received were administrative complaints, for example, incorrect payments of benefits. So they were supposed to pay 3,000 rand and then they paid 2,749 rand and 33 cents. Why? Followed by clinical complaints about the non or short payments of PMBs and non-PMB accounts. Complaints must be made in writing to the registrar, and the council's complaints unit will then consider whether the complaint is valid, checking, for example, in the case of a rejected claim, whether the claim was submitted timeously for a benefit covered by the scheme and for a benefit still available to the member that is not exhausted, and whether the rules provide for members to use specific providers or medicines in order to access benefits, and so on. The complaints unit will not consider complaints about treatment outside of South Africa. So don't complain about that. Medical practitioners who are alleged to have acted unethically, they will not deal with that, or the legal correctness of treatment rendered. No. They will also not. That you need to go to the medical board, where the doctors and specialists and hospitals must be registered. If the complaint is valid, the complaints unit must pass on the details of the complaint to the party that is the subject of the complaint. That party, usually a medical scheme, has 30 days in which to send a written response to the complaint to the registrar. So the registrar will receive the complaint and he will send it to the medical scheme. The CMS has identified the failure of schemes to respond to a complaint within 30 days as one of the weaknesses of its complaint process. So if the medical scheme responds within 30 days and is of the view that the complaint should not be upheld, the council's complaint analyst must assess the response and make a decision. So the analyst will then see what did the medical scheme come back with and whether they have a valid point or not. If the scheme does not respond in that 30 days, it seems to me is most of the cases, the complaints analyst must decide on the matter based on the available facts. And the complainant will then be informed of the decision, whether they were successful or not. And the complainant will be the member. The complainant is the member who complained. Member who complained. All right. The CMS undertakes to make a decision or ruling within 120 days. That is 4 months of the date the complaint was communicated to the parties. If the member is not happy with the decision, they have 21 days to say why they are dissatisfied. If there is no response, the file is closed. So you get your results back. If you're happy, you don't have to respond. They close the case after 21 days. If you're not happy, you've got only 21 days to reply back again. If you don't reply back again in that 21 days, they will close the case in any case. So if the complainant responds, the analyst may try to resolve the matter by arbitration or mediation. If the matter is not resolved, the registrar may give a ruling or refer it to a meeting of the members of the CMS. Anyone who is aggrieved by a decision on a complaint can appeal to the CMS in terms of Section 43 and the decision will be suspended pending the outcome of the appeal. All right. The CMS meets four times a year and must notify the parties concerned 14 days before the meeting. The parties can appear before the CMS to present their evidence or submit a written argument or explanation to the CMS or make use of a legal representative. The CMS can ask anyone who it thinks may be able to present material information to do so. After hearing the matter, the CMS can confirm or overturn the decision originally made or make its own decision. They can stick with the original decision or they can change it. A copy of the decision in writing must be sent to the registrar's office. Any person who is aggrieved by a decision of the registrar under power conferred or a duty imposed on him or her under the Act can also, in terms of Section 49, appeal to the council within 30 days of the date on which the decision was given. So make sure you know all these dates, because if you take longer, sorry, then it's too late. If that person is still not happy with the decision of the full council, they can complain to the Board of Appeal. Section 50 provides for the establishment of this board, consisting of 3 people appointed by the Minister of Health for a term of three years. One must be appointed for their legal knowledge and 2 others for their knowledge of medical medicine. Any person aggrieved by a decision of the council or the registrar, acting with the concurrence of the council, may, within 60 days, and upon a payment of a prescribed fee, appeal against such decision to the appeal board. The appeal board has the powers of the High Court to call witnesses or to call for any book, document, or object if it feels the need, and anyone who gives the board false information will be guilty of an offence. The hearings must be in public, but the chairman of the board can exclude from the hearings on any one whose presence is not necessary or desirable. The board can confirm, vary, or set aside the decision being appealed. The board's decision must be put in writing and given to the parties and the CMS. Medical scheme members who are, in terms of the rules of the scheme, not entitled to certain benefits may apply to the scheme's ex gratia committee to make an ex gratia payment. Schemes set aside some discretionary funds to make ex gratia payments, especially in cases when a member suffers undue hardship. Schemes are not, however, obliged to make these payments, and they are not in the rules of the scheme, meaning members have no right to them. It is just a nice thing that they scheme do for you. I know many years ago when I was younger, we went to Mozambique, and the people said before we go over the border, we must find out if our medical schemes will cover us while we're on holiday in Mozambique. My friends were on the higher, more expensive plans on the medical schemes. They found, at that stage, we were at Discovery. They found Discovery, and Discovery said yes, they will cover them across the border. So, should something happen to them in Mozambique, they will come and with an aeroplane, collect them, bring them to South Africa, not a problem. They're covered. I found Discovery and I said, no, my plan, because I'm on a cheaper plan, it covers only inside the borders of South Africa. So the moment I go to the border in Mozambique, sorry, I will not be covered. Well, it was the night we were still in South Africa. We slept that night in Malalan, and the next day we crossed the border. So there was nothing I could do at that stage. So I said, ah, okay, let's hope and pray for the best. We went through the border. We came to Mozambique. We had a nice holiday, but well, it started off as a nice holiday. The second day, I went with my friend's jet ski into the sea. I rode a little bit. I fell off and I broke my leg. The paramedics came there, the ambulance. They said I broke my leg on 3 places. They must take me to Injamban, to the hospital. I need to get an operation. I told them I've got a problem. Discovery don't cover me um, uh, for the operations here. They said, well, then I must pay out the money cash, which I didn't have. So then they said, I phoned Discovery. They said, sorry, somebody must bring me back to South Africa. Then they will pay for the operation. So my brother said, okay, fine. He will take me in his car. He'll take me back to the border to Nelspruit, and then Discovery will help me there. But from Injamban to Nelspruit was quite a far drive, about 15 hours drive from Injamban where we were. And the fact is that my brother have to drive a whole day there, drop me and a whole day back. So it's 2 days of his holiday. Luckily for me, two other people which I didn't know of also had accidents with their jet skis. And the one broke her a collarbone and the arm and the ribs, and the other bone. Other lady broke a femur on 2 places. They were on the higher back medical scheme options. So Discovery sent in 2 aeroplanes uh, to fetch each lady. And then the paramedic that was taking care of me, he asked Discovery if I cannot be loaded in one of the aeroplanes, since it's already coming there and taking back. Then so that my brother don't have to drive 15 hours to drop me in Nelspruit. Um, and I told the paramedic they won't do it. They told me. Luckily for me, Discovery had a change of mind. And they said, okay, well, since we're paying for the 2 aircraft there to fetch the ladies, I might as well just hop into the one plane and come back with them, saving my brother the trip. So thank you very much, Discovery. See, they did it. They wasn't supposed to do it, but sometimes they are nice and they do things like that. Any payments made do not set a precedent. So yeah, whatever you pay, it's not a precedent. What they mean by precedent is not like our president. A precedent is when you do something new and uh, other people want to follow that. They say you set the precedent so that other people can do the same. It's just a law term. Moral rules of a medical scheme. The moral rules are an administrative tool which guides medical schemes as to what the council finds acceptable and what the act requires concerning the rules of a medical scheme. Their importance cannot be underestimated. They are used as the basis for the rules of the majority of medical schemes because of the provisions of Section 31, subsection 2, which state that no rule is valid. No rule is valid unless the registrar approves it. Okay. You can go through the rules on your own time. Don't waste too much time on them. I don't. You don't really need to know all these rules. Yeah, if you get the question, it might be one, but you can decide how much time you want to spend on it. I won't worry too much about that. That's the end of this part. See you in the next part.